Douglas, can you hear me okay? I'm a quiet talker, so I definitely need this thing. I'm going to talk a little bit about the conflict of interest allegations related to the bond project and the sale of the bonds. I'm not asking you to take my opinion. So what I have for you is a series of documents. So I'm sorry, I'm going to sit so I can page through them. And to help understand what these issues are. We're going to start with the Office of the State Auditor. They raised these issues officially to the school district April 1st of last year. So I'm going to show you some excerpts from their letter. First, we're going to start off with former board member Kathy Bugholz and BWBR, who is the district's architect for the bond project. And this is an excerpt from the letter from the Office of the State Auditor. So they know if a school member has a spouse with a financial interest in a professional service contract, it's referring to the architectural contract, and the couple combine its finances, the board member would have a personal financial interest in professional service contract, which would be a conflict of interest. Again, not my opinion, Office of the State Auditor. So they directed the governing body, the school board, to determine if there is a conflict of interest. And then, if there was, abstaining from voting on the matter is not sufficient. Ms. Bugholz has continued to maintain that she did not vote on awarding the contract to BWBR, and that's sufficient to avoid a conflict of interest. That is not the case. That's not what the statute says. Specifically, in order to move forward with awarding a contract to an entity that where a member of the governing body has a personal financial interest, there's a process outlined in state law that requires the board to adopt a resolution and state that it is as low or lower than the price that could otherwise be obtained. We know in this case from the request for proposal process that BWBR was not the low cost. They were about the middle of the pack. And the interested person would need to complete an affidavit, and Ms. Bugholz never did these things. Also of concern, this is BWBR's contract with the district. And the excerpt, the compensation. And you can see the compensation is a lump sum, 6.5% of the construction cost. Why am I showing you this? Because it shows you the bigger the project, the more money BWBR makes. So recusing yourself from awarding the contract is not sufficient. Once they have the contract, every time the school board discussed or voted on the scope of the project, and any action was taken on the part of that school board member to maintain or increase the size of the project, they had a personal financial benefit. Okay? So this is the scope of the conflict of interest with Ms. Bugholz. Is that clear? Okay, moving on. The second conflict of interest raised by the State Auditor's Office had to do with the Director of Finance, Kristen Hoheisel, and R.W. Baird, who acted as the school district's financial advisor for the bond. Her husband, Michael Hoheisel, is managing partner of R.W. Baird's office in Minnesota. He is also a stockholder in the company and owner. So the Office of the State Auditor found that the district informed them that this position has no decision-making authority and therefore cannot have a conflict of interest. So this is the crux of the issue with Ms. Hoheisel. Does she have decision-making authority? If she didn't, then she couldn't influence the contract or the payment, and therefore it would be solely a board decision and there wouldn't be a possibility for a conflict of interest. The district informed the OSA that she did not have any decision-making authority. It's very clear through the documents I'll show you and the discovery process that that's not accurate. She was granted on a broad basis for all contracts $100,000 approval by the board routinely at the beginning of every year by resolution. This is the contract that was approved for the bond sale for R.W. Baird. See, it was signed in July after the referendum passed, but right before the sale of the bonds. I show this to you not to put you to sleep, but because of this rather key provision, which is really unusual. But note that under fees and expenses, there is no dollar amount. It says that Baird shall be entitled to a fee to be paid by the client equal that will be determined by mutual agreement.
That's a sweet deal.
If you can get it. Now, I also want to just tell you a little bit about me, is I've worked most of my career in local government, primarily with cities, though also at the regional and state level. And I have managed many, many public contracts for many dollar amounts. I have never, ever seen a contract absent a literal emergency. When I was working in Woodbury, they had a giant sinkhole open after a big rainstorm. They hired a contractor to investigate that sinkhole. There was a provision for paying them based on a calculation, not a dollar amount. But I have not ever seen a contract with no fee before. And this is crucial when you start thinking about the framework that the OSA provides us, decision-making authority. How much are they going to be paid? Now you see that the chair did sign the contract, but the board as a whole never approved it publicly. There's no public record of them approving this contract as a whole. And even if they didn't approve a fee. I show you, even though it's stated that that was, previously said, oh, this is typical in the financial services industry. This, before we moved to R.W. Baird, Northland Securities was the financial advisor for the district. This was our last contract with them, and under compensation, you see a specific lump sum. So to argue that it's typical is false. It wasn't even typical of our previous advisor. So to get down to the closing memorandum, this is at the sale of the bonds. R.W. Baird was paid after the bonds were sold from those proceeds. The only district member present at that closing was Kristen, an employee of hers, and she authorized the payment to Baird of a $115,000 fee. So are we connecting the dots? Does that make sense? All right, to the press, Ms. Hoheisel has argued that she got approval from the board for payment to Baird when the review and comment was submitted to the Department of Education. Just a little history. This is the required document submitted before the district could go out for a bond referendum. And it's kind of essentially laying out the educational and economic purpose for the bond referendum to the Minnesota Department of Education. They need to give it a positive recommendation, or if there's a negative recommendation, there's a different process the district needs to go through. They did that. And as part of this, there is a budget. That budget does not ever reference R.W. Baird. In fact, it references Northland Securities, and it does not ever list a line item of $115,000. It does have a lump sum for bonding costs. So her argument that that was her approval is also belied by their statements. This is from the district's brief submitted in response to my lawsuit regarding the purposes of the bond fund. And one of the arguments I made was that, hey, we have this review and comment. We have these public notices that outline all these specific uses for dollar amounts. And at that time, conveniently, the district argued, well, cost estimates included our concept level estimates. So the estimates included in the review and comment are are not binding to the district in order to answer commitments to the voter. However, they are sufficient for Ms. Hoheisel to justify paying a fee to her husband without further board action. Last document I wanted to share with you is the district also entered into a second contract with Baird in 2015 to do lease levy certificates of participation. The board was considering making Brookview even bigger than originally proposed, but ultimately elected not to proceed with that project, but they did enter into the contract. So in December of 2015, board chair signed. Again, the board as a whole did not approve or review this contract, but right there in black and white, Baird has identified the following additional potential or actual material conflict. The wife of Michael Hoheisel, the managing director of Baird's public finance team, who will be active in this engagement, serves as the issuer's director of finance and business services. So Baird did identify a conflict of interest with her decision-making authority. And they notified, at the very least, the board chair was aware when we signed this contract, but no action was taken. That's all I have. Any questions?
Who's the signature?
That is the board chair that was commenting in at that time.
So, if I heard you right, you're saying they're the company, wherever they're housed, not in Minnesota, but the corporate company,
Yes.
said, our school district, they felt this was a conflict of interest.
That's correct.
And our district said, oh no, we like both of them, so we want him.
That's correct. Other questions?
And this is for both Sis and Melissa. What are the legal remedies to both the open meeting violations and the conflict of interest? What are the remedies that either we seek or what are the potential remedies?
The potential remedies under state law for the conflict of interest is to void the contracts. And under open meeting law, I think it's touched on those,
And for open meeting law, the remedy is there's a fine for the first two offenses and then possible removal of office for the third. There is, the way this works, and this is because of precedent, it's not just one offense. So let's say board members met at a restaurant on X date, a quorum met, they discussed board business, it was an offense. If that's brought as a lawsuit, but lumped in over a period of time with, let's say, 1 or even 100 different open meeting violations, they are all cumulatively considered to be one because it's one adjudication. So the standard is very, very hard to meet. And that's why, and so there have been separate lawsuits filed with separate incidences. It has to be adjudicated, and once it's adjudicated, it would go to the next one. That would have to be adjudicated, and then it would have to go to the next one. And the thing that's so difficult about that precedent is that you consider the typical term in office for a public official and the amount of time it takes to run through the legal system for you to get one adjudication and then to wait for the next suit. I mean, it's almost an impossible standard to achieve to get to the third offense where removal of office would be the remedy.
Sis, I have a question for you. You know how this final one, that's where the hearing is in October? It just seems like it's been dragging on for a long time. Is there a reason why it just takes so long to have this lawsuit process? Is it because there were so many pieces of it in the first place? And it was going to be really hard?
I don't know the answer to that. I really don't. I mean, this one in October is really the very first lawsuit that was filed. It was the first one, but this lawsuit admittedly had multiple counts, and several of those counts have been dismissed. The other lawsuits that were filed, in fact, the Melissa Douglas case was a very narrow, very focused suit that dealt with one specific issue. The other 834 case, it was also a school closure, an illegal school closure case, was also a very narrow question that went to the court. But, why it is that the Court of Appeals would hear that sooner than district court, I don't know the answer to that.
I can just tell you under, in the state of Minnesota, the Court of Appeals does have a fairly aggressive time compliance with your cases. And there's, especially in the school closing case, there wasn't a discovery process per se. They just relied on the existing record. And so that allowed it to proceed a little bit faster. And my case was very narrow, and so also there wasn't a discovery in the sense of exploring reasons why, or the process that looked at the legal issue of use of bond funds and what defined the purpose. I argued that the review and comment of public notice, the mailings to parents, define the purpose in addition to the ballot language. And as some of you may know, unfortunately, the judge limited the purpose to the definition of the summary ballot language.
I just have a follow-up question for the ballot language. What was the part of the ballot language? Because when I read the ballot language, it doesn't look like we're closing schools or anything like that. What was, I mean, do you know offhand, like, what was the particular part where they said close schools?
It's a little bit of the grammar.
Could you speak up a little more?
Yes, can you hear a little bit better now? There we go. It's a little bit an analysis of the grammar in the ballot language. There was the word including, which the court, based on precedent, takes to mean a non-exclusive list. And then there was references to existing sites and facilities. And it specifically said existing elementary sites and facilities. If you went up further in the ballot, and I'm sorry this is a little boring, but this is, it talked about the high school site and facility. So referencing the property, the site improvements, like the athletic improvements, and the facility being the building. So I read it that the existing sites and elementary sites and facilities was referring to the elementary property and the elementary facilities. So I thought elementary modified both sites and facilities, but the judge said no. So by saying
any voter know
including
that?
and facilities.
Voters are not doing grammar, so.
No, and I think the voters would have legitimately relied on the public notice in the paper,
Yes.
the mailers to their home, and the public hearing information presented through the review and comment approval process as the board. So it goes without saying that I think it's a tragic decision. And unfortunately, our legal remedies aren't promising with addressing that issue.
So, back to the conflict of